We'll get to that understanding by reviewing the steps in a grievance procedure, understanding the functions of these grievance procedures, what constitutes employee misconduct, what are the disciplinary procedures that are available, what about grievance mediation where we can't get some sort of agreement on both sides, and then how does our private sector grievance process and procedure differ from our public sector grievance issues. When we talk about our grievance, we're really talking about any perceived violation of a contract provision. The definition could be broadened to include any complaint by an employee against an employer and vice versa. It's interesting that one arbitrator provided a classic definition. If a man thinks he has a grievance, he has a grievance. However, a more precise definition might include any formal complaint lodged by persons who believe they've been wronged. It's really not a gripe, which is generally defined as a complaint by an employee concerning an action by management that does not violate the contract, past practice, or law. For example, an employee might only have a gripe if his supervisor speaks to him in a harsh tone, but when the supervisor assigns him work outside his job classification, he may have a grievance. And here we're covering what the steps in a grievance procedure would look like. And in the initial steps in the grievance procedure usually instructs the employee to discuss the grievance with the shop steward, who is the employee's union representative on the floor, or go directly to the supervisor. The employee has the legal right to do the latter, that is, go to the supervisor, and the supervisor must resolve the grievance consistent with the contract. So secondly, if the steward and employee agree that the grievance has some merit and should be pursued, then the grievance is reduced to writing. At this point, the grievance is said to have moved from the informal to the formal stage. The steward and employee complete a grievance form within a specified period, which is usually 48 hours of the occurrence or within the time limit specified in the contract. The third step is that when the shop steward and supervisor cannot resolve the grievance, then it may be appealed to the next higher level of management and union representative, usually within 7 calendar days. At this point, the union representatives come to the shop steward or business agent. However, the management representative usually represents a higher level and may not be a plant superintendent or department head. It may be the plant superintendent or department head. When we move to step 4, then, the plant manager or department head may be assisted by the director of personnel and industrial relations in reviewing the grievance from a management perspective. As with the second step, they review the written grievance and discuss the case with the employee's representatives. The two sides continue to try to resolve the grievance honestly rather than go to the final stage of the process, which is final and binding arbitration. However, if it needs to get to that, then approximately 98% of all collective bargaining agreements provide for a binding arbitration as the final step. In that step, it requires that the request to go to that must be made within a specified time period, such as 30 calendar days of the receipt of the answer of step 4. The outside independent arbitrator studies the evidence and listens to both arguments on both sides before rendering a decision. The arbitrator's decision, which is agreed to in the collective bargaining agreement, is final and binding on both parties, but can be appealed to the courts only if there were grounds of collusion, or if the arbitrator's award exceeded his or her authority, or if the arbitrator's decision was not based on the essence of the labor agreement. And so we see that there are these 5 steps, and with the final step being arbitration, which essentially means we were not successful in any of the previous steps in resolving whatever the complaint was. So formal grievance procedures are the most common tool to resolve conflicts between labor and management during the life of the agreement. The functions which are provided by the grievance procedure include conflict management resolution, agreement clarifications, since all agreements contain a certain amount of unintentional ambiguity that results in questions requiring contract interpretation. Communications, these grievance procedures provide a vehicle for individual employees to express their problems and perceptions. They also offer the employees a formal process to air perceived inequities in the workplace. It's also the function of dual process, where we involve a neutral third-party intervention. Most grievance procedures provide a fair and equitable due process containing binding arbitration as the final step. And then this idea of strength enhancement. So the grievance mechanisms help unions develop employee loyalty and trust. Grievance processing emphasizes union presence and strength during the term of the collective bargaining agreement and reminds employees that the union's efforts to protect their interests. In labor relations, the term misconduct applies to a broad spectrum of offenses, which range from relatively minor ones, such as discourteous behavior, to major ones, which include theft and picket line violence. The basic maxim or premise established early in the history of U.S. labor relations is that incidents of employee misconduct would be looked at as either a serious offense, which under normal circumstances would warrant immediate discharge without the necessity of any prior warnings or attempts at corrective actions, or minor offenses, which call for attempts at corrective actions and don't call for discharge for the first offense. However, these minor offenses can, when repeated despite warnings, lead to discharge. Employee misconduct cases that are decided by arbitration often are won or lost, not because of the questions of guilt or innocence, but because of these issues noted here, such as management's consistent enforcement of the rules that are involved in the case, management's compliance with the disciplinary procedures in the contract, an employee's work history, and an employee's length of service with the company. And there are certain examples or common examples of employee misconduct and some of the key factors that are considered by arbitrators that include damaging company property, discourtesy, dishonesty, dress and grooming, email and technology issues, gambling, garnishment, horseplay, off-duty misconduct, moonlighting, and sleeping and loafing, and violence. So certain incidents of employee misconduct that are generally considered minor offenses include activities like loafing during working hours, failure to attend meetings, attending to personal business during working hours, failure to keep a time card, minor insubordination, carelessness, and perhaps poor work performance. Under most labor agreements, the penalty for a minor offense is determined by how often it has occurred. Such a system of progressive discipline, right, and so that's where it's a progressive discipline referring to a discipline system for addressing minor employee misconduct that usually includes several levels of penalties such as warnings, reprimands, suspensions, and then finally termination, with the objective being to inform an employee of inappropriate behavior and enable the employee to correct such behavior without serious or permanent consequences. So we see that there are usually several levels of penalties under this progressive discipline approach for minor offenses, and examples of this might be a first offense, which comprised of an oral warning, a second offense, which is responded to by management with a written warning, a third offense, which is a second written warning and suspension without pay, and then on the fourth offense of one of these minor offenses, termination. And then we go back to this idea of serious offenses, which under normal circumstances warrant immediate discharge without the necessity of prior warnings or attempts at corrective actions. So under this situation, the discharge must be for just cause. That is, the employer must be able to point to the violation of a serious offense. The serious offenses are usually identified in the contract, so an employee generally knows whether their action would be deemed upon discovery a serious offense or a minor offense. And then the arbitrators expect both parties to carefully adhere to the letter and spirit of the contract in determining between serious and minor offenses when deciding the disciplinary action necessary. Here we see table 11.1, which is in our text on page 421, and this really gives the most common grounds for discharge that are specified in contracts, and we see that there are items like unsatisfactory work performance, unauthorized absence, insubordination, dishonesty, failure to follow safety rules is a big issue, and an employer could easily point to that in that they jeopardize the safety of fellow workers, conviction of a job-related crime, workplace violence, violation of work rules. These are all what we could deem that would be normally listed in a CBA as serious offenses that could result in immediate discharge. A last chance agreement is an agreement between the union and the employer that allows an employee who is fired for misconduct his or her job back, with the condition that if the employee violates the last chance agreement, or LCA, that he or she will be discharged without a right of appeal. So one view of these LCAs is that it's separate from the collective bargaining agreement and will be strictly enforced. That is, the employee will be terminated if the LCA is violated. So it's an agreement that's outside the CBA, and if an employee violates it, they are discharged. And that is the consequence of violating an LCA. A second view is that they represent a mutually accepted modification to the CBA, in which the employer has forfeited the right to immediate discharge in favor of giving the employee a last chance, and the employee has given up the right to arbitrate or litigate a potential termination in favor of a retention within the specified or specifics of the LCA. So we know that the primary objective of the grievance process is to provide employees with a fair review and, if necessary, an appeal of disciplinary actions taken by management. Regardless of the size or industry, every company at some time must administer corrective discipline. Certain employees may need such attention only once or twice in their careers and quickly respond to fair procedures, where others may never correct their behavior and will exhaust any progressive disciplinary process. However, other employees must believe the disciplined employees was given a fair chance and equitable punishment. So to maintain good labor relations, both labor and management should strive for fair and effective disciplinary procedures. Employees are more satisfied when they know what consequences to expect from rule violation and when they see disciplinary procedures administered consistently. We define disciplinary procedures as processes that are usually designed to set standards of performance and work rules and apply discipline up to the point of termination when those standards aren't followed in a fair and consistent manner. The general purpose of these procedures is to reduce the number of violations. Labor and management officials want to minimize the use of disciplinary actions, but both realize such actions will be needed in some situations, and so virtually all CBAs outline a disciplinary procedure. And so a variety of disciplinary policies may be provided for in a labor contract. However, the Bureau of National Labor Affairs suggests that management and labor officials use these policies in getting to what employees could perceive or should perceive as fair disciplinary procedures. So one is to explain the company rules, and we do that through orientation courses, employee handbooks, bulletin board notices, emails, and any other device that can be used to bring work rules to the attention of employees. We investigate fairly and objectively by interviewing witnesses to ensure that both sides of the story are presented, that is, get the facts. We give adequate warning. Most grievance warning steps are given to the employees in writing. However, all warnings, even oral warnings, should be noted in the employee's personnel record. We ascertain a motive. That is, people usually have a reason for what they do. They seldom intentionally and maliciously violate rules. So the penalty should be adjusted to the degree of the employee's actions that was intentional. We consider the employee's past record. Before taking disciplinary action, we want to take into account good work history and seniority, especially cases of minor offenses. We don't want to discipline without discharge. Whenever possible, we want to avoid the use of discharge. We only use when there is no hope of future improvement or the offense is severe. And then lastly, we want to act in a timely fashion. So we should issue discipline in a timely manner within a reasonable period after the misconduct. In most cases, the further removed the disciplinary meeting is from the event, the less productive the discussion. Most collective bargaining agreements include procedures to resolve grievances that arise during the life of the contract, with binding arbitration as the last step. Increasingly, however, contracts are providing for grievance mediation. And when we talk about grievance mediation, we're talking about the use of a neutral third party as one step in the grievance procedure. The mediator, in a confidential process, facilitates the parties developing a resolution of the grievance themselves and thus avoid arbitration. The process provides the opportunity for a neutral third party or a local mediation service to assist the parties in reaching their own settlement of the dispute before it reaches arbitration. It's not a supplement to or a single step in a contractual grievance resolution process, but should not be viewed as a substitute for the process. The mediator cannot resolve the dispute by making a binding decision, but rather works with both parties to achieve a mutually acceptable settlement of the grievance. And so here we see what some of the advantages of a grievance mediation process is. Items such as faster resolutions of issues compared to arbitration, that both parties may present their case to a mediator, that grievance mediation enables both parties to reevaluate their cases before proceeding to arbitration, and that federal mediation and conciliation services provide the service without a charge. So there are some good advantages to this idea of grievance mediation, which occurs, as we said earlier, before a case or a grievance gets to the arbitration stage. And if we look at the use of grievance mediation in comparison to arbitration, we'll see that the average cost of mediation is much less than arbitration, so there's this cost savings. The average time to mediate a case was much less than the average time it took for a case to get to arbitration. The participants were highly satisfied with interest-based mediation, included 89% of management, 68% of union, and 47% of grievance as concluded from a 2005 study of 3,300 cases over a 24-year period. And then it was also indicated that these participants were better able to resolve future agreements or grievances because they learned how to communicate better through the use of a grievance mediator. As we talked this semester thus far, there are significant differences between public and private sector labor relations. However, the grievance process is a major similarity, that the collective bargaining agreement of both sectors are influenced by the personalities of the negotiators and their abilities to improve their bargaining power relative to the other party. Also, grievances in the two sectors are generally processed in the same manner. The expense of grievance arbitration is a major concern to employers in the public sector, just as it is to those in the private sector. In the area of discipline and dismissal, however, public sector law has developed along completely different lines because of the constitutional protection afforded government employees. When government acts at any level to discipline or dismiss an employee, a form of state action has occurred. The power of the state over an individual is curtailed by the Bill of Rights, and any constitutionally protected right is infringed on by the discipline or dismissal of an employee. Then that employee has a valid claim against the government entity, regardless of contractual rights. So examples of these constitutionally protected rights include the privilege against self-incrimination, freedom of association, the right to participate in partisan politics, and the freedom of expression. This concludes chapter 11, which again dealt with the grievance and disciplinary procedures, and I hope you got some appreciation of the level of formality that is generally reserved for these actions, yet the opportunities to resolve issues informally when possible, and also the importance of this procedure and the concepts around it, since this really is what takes up the day-to-day time of a union. And a union works hard to protect its members, because it's this grievance process that for many employees is where the value of the union comes in. So I encourage you to read chapter 11 closely, and then please move to completing the discussion forums and the assignments. Thanks for your attention.